All right. Well, good afternoon, everyone. I'd like to welcome all of you to our webinar today, representing clients in Missouri's medical marijuana industry. So this CLE has been approved for 1.2 hours in Missouri, which includes 0.6 ethics hours, 1 hour in Kansas, which includes 0.5 ethics hours, and 1 hour in Arkansas. My name is Jennifer Matthew. I am the Director of ADR and Counsel for Alaris. I'd like to welcome all of you here today. I just have a few housekeeping items, and then we will get to the subject at hand. We do have another CLE next month. It's going to be a live replay of a webinar we did earlier this year. It's for ethics credit. Whitney Dunn presented it from the Bar Plan, and it's called The Quiz. And that registration is currently open. So if you'd like to register for that, again, it's on December 15th. And you're stuck with me. I'm going to be your live moderator, but it is a replay of a former CLE. And check back to our website for more CLEs coming up next year, and that is alarisadr.us. So after the webinar has concluded today, you will receive a survey. It's going to be a link from Zoom tomorrow. We're always looking for ways to improve, and we will happily share your comments with the speaker. So please take that survey to help us do better. We actually are no longer sending certificates of service. So this is something, certificates of attendance, not certificates of service. We usually do send those out, but we actually aren't required to, and we're going to stop doing that. And so for some of you that rely on those, I'm going to post in the chat the codes for each state, but there is credit, as I mentioned, for Missouri, Kansas, and Arkansas. So please keep track of that. We do let Arkansas and Kansas know who attended. So that is important to let you know that, but as we know in Missouri, we're on our own anyway. So I'll put those all in the chat when I stop talking. And also there will be 2 poll questions during the webinar, so keep an eye out for those of you seeking Kansas credit. Just go ahead and submit your answers. And then lastly, if you're joining us by phone only, I see there's about 3 of you currently, send an email to cle@alaris.us or to me, which is jmatthew@alaris.us, just to make sure that you receive, that we know that you are attending, in particular if you are seeking Kansas credit. So anyway, if you have any other questions during the presentation, I think Lauren is happy to answer them and get to as many as she can. We like to use the Q&A link at the bottom there, so please submit them. And I will try not to interrupt you, but if it's relevant to what you're talking about, we'll go ahead and answer those. So thank you, Lauren, for that. So it is my pleasure to introduce Ms. Lauren Collins. She is a litigation attorney for the in-house firm of the Automobile Club of Missouri, which is currently known as Kraft, Bischoff, Buckley, and Collins. Lauren obtained her law degree from the University of Missouri School of Law in 2013. She began her legal career as a prosecutor in the city of St. Louis, where she tried numerous bench and jury trials. After a few years there, she went into private practice working as an associate with Hepler Broom and then later Sandberg Phoenix. Currently, Lauren serves as the chair of the Young Lawyers Division for BAMSL. She's an adjunct professor at St. Louis University School of Law, where she teaches, not surprisingly, marijuana law. On a personal note, I've been friends with Lauren for years, and when she told me what she was teaching, I of course asked her if she would be willing to do a CLE on this topic, and she very kindly said yes. So thank you for that, Lauren. For me personally, this is an area of the law I know nothing about, and so I think it's going to be fascinating, and we appreciate your time. So I will turn it over to you, my dear.
Thank you so much, Jen. Good afternoon, everyone. Thank you for being here with us today. Greatly appreciated. So as Jen stated, and sorry, I'm going to go ahead and get my screen shared with you all. That should be good. Just 1 second. Okay. All right, so as Jen stated, my name is Lauren Collins. I'm currently a litigation attorney, the in-house counsel firm for the Automobile Club of Missouri. Kind of just briefly piggybacking off of what Jen said about my experience. I started my cannabis practice when I was at Sandberg Phoenix. So this was after medical marijuana was legalized in the state of Missouri. And kind of just got into it because I found it interesting. And I actually got a call from someone out in Houston, Texas, who was looking to get into the industry. We did not have a cannabis practice, but we quickly started one as we realized that we could service clients regarding all aspects. of the cannabis industry. And from there, when I left Sandburg, Phoenix, I had to give up my cannabis practice, which I enjoyed so very much. But I had an opportunity to teach cannabis law and policy at SLU Law School. So I am thoroughly enjoying that and enjoying kind of keeping some type of hand in the cannabis law area. So I'm excited to be here today and kind of share my knowledge with all of you. So let's go ahead and get started. So I want to start off with some statistics. As of May 2020, 36 states, 4 out of 5 permanently inhabited US territories, and the District of Columbia have some form of legal medical marijuana laws, which allow for patients with a number of physical conditions and or health issues to obtain, possess, and sometimes even cultivate cannabis and use it for treatment. Now, those numbers you might notice only relate to medical marijuana. So the number only rises when you introduce recreational marijuana to the stat. In November of 2018, the citizens of Missouri voted to adopt Constitutional Amendment 2, which allows for the cultivation, manufacturing, transport, sale, possession, and usage of medical marijuana. And that is just in this state. That amendment also shields licensed patients, caregivers, cultivators, processors and distributors from liability, as well as doctors and lawyers. So what these statistics really talk about is what has been happening in a lot of states across the nation, which is regulatory reform of marijuana. Regulatory reform in the states has been going on for nearly 2 decades. And when we discuss reform, what we're talking about is the content of marijuana regulations, which essentially deals with who may use the drug, the wisdom of competing regulatory approaches, which deals with whether or not states can legalize marijuana while use and possession is strictly prohibited by Congress. And then also the authority of different government actors, and that deals with preemption issues. So one might ask, when talking about marijuana or representing clients in medical marijuana, why do we care? And for one, it's interesting. Like I said, I got into this because I just found it to be an interesting topic. Also, it's a new area of law, which also makes it fun to learn about and see how it develops. And because it's a new area of law, it's very fluid, and it's kind of developing as things come up, as issues come up in the field. So that's one reason to care. Also, another reason is the laws and policies governing marijuana affect a huge segment of the population. At last count, something like 44% of Americans aged 12 and older have tried marijuana sometime during their lives, and more than 22 million Americans are considered regular users. The demand for marijuana has attracted a large number of people willing to grow and distribute the drug. So there, and also there are a number of third parties who interact with users, and suppliers are increasingly being drawn into the ambit of this field. So when we're talking about third parties, we're talking about lawyers like ourselves, physicians, bankers, insurers, employers, just to name a few. Another reason to care about this field of law is that there is a need for informed legal advice. And that's because marijuana is a highly regulated substance. The laws regarding the regulation of marijuana are complex, and there is a need for compliance under those regulations. Also, have to take into consideration the effect on public health. There is a belief that there is a beneficial use for marijuana in treating or alleviating pain, and on the other hand, there is a belief that marijuana is harmful because it impairs driving and lacks any medical benefits. Another thing to consider in determining why we should care about this field of law is the effect that it has on public finances. So money spent by those jurisdictions, those states that completely prohibit marijuana to enforce bans on marijuana totaled between an estimated 1.2 billion to 6 billion back in 2010. Reform states like Missouri have been able to turn marijuana into a net revenue generator by legalizing and taxing the drug. So just kind of give you an idea of what that looks like. The state of Colorado reported collecting $103 million in taxes and fees back in 2015. And then lastly, why we should care about medical marijuana law is the possible lessons for other fields. Marijuana law can potentially be used as an example to explore other important legal topics that are relevant for lawyers working in a range of fields and industries. So some statistics specific to Missouri. So after the passage of Amendment 2, which legalized medical marijuana in the state of Missouri, there was an application phase for those wanting to open up facilities in the state. That application phase has since passed, but during that process where individuals and different companies basically submitted an application to the state asking to open a type of facility, which was either cultivation, infused products, or also known as manufacturing facility, dispensaries, laboratory testing, and transportation licenses. There were a total of 370 facilities in the state of Missouri that received licenses, and a breakdown of that in also just to kind of show you all how competitive that application process was here in the state of Missouri. There were 60 cultivation licenses that were issued, and there were 557 applications received. For infused products, there were a total of 86 licenses that were issued with 416 applications. Dispensary, which had the most licenses issued, was 192 licenses, and they had a total of 1,162 applications submitted for dispensary licenses. So it was an extremely competitive process, but it also was one of the, I guess, the first steps to representing clients in the medical marijuana industry here in Missouri, helping clients kind of prepare those applications, make sure that they had everything that was needed, whether it was the appropriate building, corporate governance, all of those things, in order to receive a facility license. So under the Missouri Medical Marijuana Act, who can possess? Licensed businesses, qualified patients, and their caregivers may possess medical cannabis. So Missouri is like every other medical marijuana state in that it limits access to those individuals who have been diagnosed with a condition that state policymakers believe would benefit from the use of marijuana. States enumerate qualifying conditions either via statute or regulation, and only patients who have been diagnosed with one of the specifically enumerated conditions may claim the protections afforded by the state's medical marijuana law. medical marijuana regimes do not allow people to use marijuana for non-medical purposes. So individuals have to obtain a valid physician's recommendation in order to legally possess medical marijuana in the state of Missouri. So a person could not say, I have the same condition as my friend down the street. He is allowed to possess and use medical marijuana, so therefore I should be able to also. And to be quite honest, the way that the regulations and the laws are set up, you wouldn't even be able to walk into a dispensary and purchase marijuana without having that indication that you are a qualified patient. So the requirements to become a qualified patient typically are to obtain a diagnosis with a qualifying condition. And it should be noted that the state has laid out and determined what those qualified conditions are. Also obtain a physician's recommendation to use marijuana. So you have to go to a licensed physician, and that physician has to make a recommendation that you would benefit from the use of marijuana. So what we saw happening here in the state of Missouri, once marijuana was legalized for medical purposes, there were a lot of physicians that had pop-up shops that came from different states and would set up and say, hey, come see me, pay me $100. I can qualify you as a patient. You can then go and get your medical card. And it's important to note that that might work on the front end, once you apply. But if there is any type of scrutiny, if the state was to do any type of digging and found out that this physician was not a qualified physician, was not licensed to practice in the state of Missouri, not only would that physician be subject to criminal sanctions, but you could as well as a patient. So after obtaining a diagnosis with a qualifying condition and then obtaining a physician's recommendation to use marijuana, the individual then has to register with the state agency. So the individual has to fill out an application and then provide any information it is that the state is asking for in order to determine whether or not that person is an actual qualified patient. And lastly, the individual would have to be a state resident. In Missouri, the state of Missouri actually requires that that physician certification is obtained annually, which means that you would have to go back and renew your certification with your physician if you want to continue to benefit from the use of medical marijuana here in Missouri. Note that the dominant rule is that a patient must obtain the qualifying diagnosis and recommendation before taking possession of or using marijuana. So an individual is not allowed to begin using marijuana, purchasing it, possessing it, and then on the back end saying, hey, I'm going to go and obtain my qualifying diagnosis and my certification. You have to have that before you are allowed to use and possess. So in talking about who can possess, the state looks at two different types of possession. So there's a personal supply and then there's the commercial supply. So in Missouri, users are permitted to produce marijuana for their own consumption, and or private businesses are allowed to produce marijuana and sell it to other users. Qualified patients are limited to 4 ounces per month unless a greater amount is certified by a physician as necessary. And that's something to think about, because if you are charged with unlawful possession of marijuana and it happens to be, and say you're a qualified patient, but you happen to have 10 ounces on you, you are in violation of the state law. Qualified patients may also apply for a home cultivation license to grow up to 4 plants. There are some states where medical marijuana is legal that actually allow their qualified patients to not only grow their own marijuana for their own personal consumption, but they allow them to grow it and sell it to other qualified patients. That's not the case here in Missouri. Qualified patients can only grow their own supply for their own consumption. Now, when talking about a commercial supply, which is again private businesses producing marijuana and then selling it to users, Missouri has authorized businesses to produce and sell marijuana to qualifying users. Commercial suppliers can take many forms. They can be big, small, for-profit, nonprofit, etc. As touched on earlier when we were talking about the some of the statistics here in the state of Missouri and the application process, obtaining a license is not easy. Missouri imposed eligibility criteria on licenses, and because there was a cap on the number of licenses that were awarded, there was also a criteria adopted to award those licenses. So basically there was a grading system in the event which was anticipated that there were more applications received than the number of licenses that the state was willing to award. So there was this grading scale that the state went through in order to determine who would actually be awarded a license for the various types of facilities. Additionally, licensees are required to test their products and must abide by specific rules for labeling and packaging products. There are restrictions for advertising. Typically, the general requirements that no deceptive, false, or misleading statements. Also, licensees are not allowed to advertise via television, radio. If you just think about it, being here in the state of Missouri, you haven't seen any commercials for any medical marijuana facilities, and that's because it is restricted by the state of Missouri. There is also a reporting requirement where licensees must collect and report information on their operations to the Department of Health and Senior Services. This information helps monitor compliance with regulations. In addition, when talking about who can possess, and just going back to that requirement of getting certified, like I said, a physician may only certify. It's important to note the distinction that physicians are not allowed to prescribe medical marijuana. Instead, they have to certify a individual for the use of medical marijuana. Looks like we have our first poll question. All right, so who is regulating all of this? The medical marijuana program in Missouri is being regulated by the Department of Health and Senior Services under Article 14, Section 1 of the Missouri Constitution, the right to access medical marijuana. What is being regulated are patient services, operations, facility licensing, and facility compliance. So the facility licensing part of it is kind of obsolete at this point. As I said, that that part of it is over, it's closed, unless at some point the state decides that there's a need for more facilities given the demand, or if at some point in the future the state there's a decision to legalize marijuana for recreational purposes, then you might see the facility licensing part of it come back into play, as there may be a need to open up more facilities. So the Department of Health and Senior Services is responsible for approving qualified patients, for reviewing applications and issuing facility licenses, and for making sure the facilities remain in compliance. That includes making sure facilities have proper security protocols in place, that they are properly staffed, that the staff is properly trained, that facilities are using, are doing the appropriate testing as required, that they are using the appropriate transportation services. All of that falls under the Department of Health and Senior Services. So you're probably wondering, or you probably heard, or you already know that marijuana is still illegal at the federal level. So I want to talk about how the federal government plays a role in this. So marijuana is a Schedule I controlled substance under the Federal Controlled Substances Act, or the CSA, in the Department of Justice. What that means is that marijuana is completely illegal at the federal level. There are no exceptions to that rule. You may not possess it, you may not distribute it, you may not use it at the federal level. The federal government has always maintained that marijuana is a harmful drug. Federal government has the power to regulate the possession and use of marijuana. So Congress created the CSA scheduling system and placed marijuana on Schedule I, which effectively bans possession, use, manufacturing, and distribution under federal law. However, Congress could pass new legislation to reschedule or even exempt, effectively removing marijuana from the CSA scheduling program. This is something that it did with tobacco and alcohol. The federal government has always maintained that marijuana is a harmful drug. The factors that are required to be considered by the DEA in making scheduling decisions are the drug's potential for abuse, its pharmacological effects, its risks to public health, and its dependence liability. Essentially, usage of marijuana is restricted by the federal government because it has been deemed harmful. It's important to note that the CSA does not make harm a scheduling criteria. However, two of the scheduling criteria, which are whether the drug has a potential for abuse and whether it is safe for medical use, are harm related. In 2016, the Department of Health and Human Services provided a recommendation to the federal government, and that recommendation was for maintaining marijuana in the Schedule I of controlled substances. And to briefly talk about the HHS's findings, those findings were organized around 4 factors, which are required to be considered when making scheduling determinations. The first factor is a drug's actual or relative potential for abuse. So under the Controlled Substances Act, the Controlled Substances Act legislative history suggests the following in determining whether a particular drug or substance has potential for abuse. And that is evidence that individuals are taking the drug in amounts sufficient to create a hazard to their health or safety of other individuals in the community. So think about, when you're thinking about marijuana, think about like driving while impaired, something similar to, driving under the influence of alcohol, right? There is significant diversion of the drug from legitimate drug channels. Individuals are taking the drug on their own initiative rather than on the basis of medical advice from a practitioner licensed at law to administer such drugs in the course of their professional practice. So one of the things I typically talk about in my class when looking at these determining factors is that when you listen to them and note that it says like evidence that individuals are taking the drug in amounts sufficient to create a hazard to their health or safety or the public, significant diversion of the drug, and even individuals taking the drug on their own initiative, it sounds a lot like alcohol or even prescription drugs. So one has to wonder why the federal government wants to continue to keep marijuana as a Schedule I drug when things like alcohol are readily available for purchase. So the second of the 4 factors required to be considered when making scheduling determinations is the scientific evidence of the pharmacological effects, if known. And what is looked at under this factor is the psychoactive effects of the drug, behavioral impairment, behavioral effect of prenatal exposure, association of marijuana use with psychosis, cardiovascular and autonomic effects, and respiratory effects. Factor number 3 is the risk to public health, if any. And the 4th and final factor is its psychic or its physiological dependence liability. So under the federal government, knowing that marijuana is completely prohibited and barred from use and possession, distribution, manufacturing at the federal government, you have to ask, well, how is it that individuals can get away with manufacturing, cultivating, selling, distributing marijuana at the state level? So there are current enforcement actions by the federal government that are somewhat limited by the federal legislation. The one that is kind of talked about the most is the Rohrabacher-Blumenauer Amendment, which was passed in December of 2019. And basically the amendment stated that none of the funds made available under this act to the Department of Justice may be used with respect to any of the states to prevent any of them from implementing their own laws that authorize the use, distribution, possession, or cultivation of medical marijuana. So essentially, this amendment prohibits the U.S. Department of Justice from using appropriated funds to interfere with state legal, emphasis on legal cannabis programs. So if you have a client who is not involved in a state legal cannabis program, you would advise them that they are still subject to federal sanctions. Before that enforcement, the Rohrabacher-Blumenauer amendment enforcement was limited by the Cole Memorandum. Now, you should note that the amendment does allow the DOJ to prosecute individuals who do not strictly comply with all state law conditions. So we talked about some of the regulations, how it's highly regulated and how facilities have to stay in compliance. Those facilities fall out of compliance. They are subject to prosecution by the DOJ. Under that possibility, potential defendants are entitled to evidentiary hearings to determine whether their conduct was completely authorized by state law. For example, they strictly complied with all the relevant conditions imposed by state law. Essentially, what it boils down to is that the federal government just doesn't have the resources to go out and prosecute possible defendants or potential defendants in states where it is illegal. So prior to states legalizing marijuana, the federal government relied heavily on states for the prosecution of violation of drug laws because many state laws related to drugs mirrored the CSA. Now the states have began legalizing marijuana use and possession. The federal government just doesn't have the resources to prosecute marijuana law violations at the federal level. In order to do so, the federal government would have to obtain more resources by hiring more law enforcement agents, judges, prosecutors, etc. So for the time being, the DOJ is not pursuing legal action against most state licensed marijuana suppliers. Obviously, there are some exceptions to the rules. Like I said earlier, if there is someone not in compliance with those state regulations, then they obviously could face legal action. So representing clients in Missouri's medical marijuana industry, the biggest question is whether or not an attorney is subject to ethical issues if they represent a client under Missouri's medical marijuana laws. So there is a strong demand for attorneys to help clients navigate the complicated rules governing the laws, the use and supply of marijuana. In addition to regulations that apply to the general population, attorneys are also subject to rules of professional conduct that govern the legal profession. All states, not just Missouri, but all states have adopted some version of the American Bar Association model rule of professional conduct. So in Missouri, that specifically what we're looking at is Rule 4-1.2F, which states a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent, but a lawyer may discuss the legal consequences with a client and may counsel or assist a client to make a good faith effort to determine the validity, scope, meaning, or application of the law. That Missouri rule of professional conduct, Rule 4-1.2F, mirrors the ABA's model rule of professional conduct, Rule 1.2D. When the state of Missouri decided to reform medical marijuana and it was legalized in the state of Missouri, they also drafted Missouri Constitution Article 14, Section 1.58, which states an attorney shall not be subject to disciplinary action by the State Bar Association or other professional licensing body for owning, operating, investing in, being employed by, contracting with, or providing legal assistance to prospective or licensed medical marijuana testing facilities, medical marijuana cultivation facilities, medical marijuana dispensary facilities, medical marijuana infused product manufacturing facilities, qualifying patients, primary caregivers, physicians, healthcare providers, or others related to activity that is no longer subject to criminal penalties under state law pursuant to this section. So it's very clear from that an individual is not subject to disciplinary action related to activities that are no longer subject to criminal penalties under state law. However, the question is, what about those activities that are subject to penalties, criminal penalties under federal law? Unfortunately, the state of Missouri has not been very clear about whether or not an attorney would be subject to disciplinary action if they violated federal law. There has been an opinion presented on this. It's an informal advisory opinion, 2014-04, which started with the question of, may an attorney ethically assist a client in setting up an enterprise for the production and distribution of a product as authorized by Missouri law, where one or more of the activities of the enterprise would violate the Federal Controlled Substances Act. The opinion or the answer that was given, and it's kind of lengthy, was whether the client's enterprise would violate state or federal law is a question of law outside the scope of this opinion. Rule 4-1.2F prohibits attorneys from counseling or assisting clients in conduct the attorney knows is criminal or fraudulent. Pursuant to rules 4-1.2G and 4-1.4A3, attorney could consult with the client regarding the relevant limitations on attorney's conduct. In keeping with Rule 1.4B, attorney should explain to client any inconsistencies between state and federal law to the extent reasonably necessary to allow the client to make informed decisions about the representation. Rule 4-1.2F allows attorneys to discuss with client the legal consequences of any proposed conduct and to counsel or assist client in making a good faith effort to determine the validity, scope, meaning, or application of the law. In light of possible inconsistencies between state and federal law in this matter, attorneys should consider limiting the scope of representation and attorney's role pursuant to 4-1.2C. The rule requires clients informed consent in writing, signed by client to the essential terms of the representation and attorney's limited role. Under Rule 4-8.4, it is professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct or to commit a criminal act that reflects adversely on a lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. Nothing in this informal opinion purports to restrict the appropriate disciplinary authority from prosecuting an attorney for a violation of this rule or other applicable rules of professional conduct. So again, they left us out to dry. This formal opinion really gives us nothing. Kind of a breakdown of that lengthy opinion is whether or not the client's conduct violates federal law is outside the scope of the opinion. So they didn't even address that. The opinion says an attorney can advise a client of inconsistencies in the law and the potential consequences of the client's intended conduct and can limit the scope of representation to only legally permissible conduct. So again, not much help. So in talking about violations of the rules of professional conduct, jurisdictions with similar laws have come to different conclusions about the implications of Rule 1.2D for attorneys who work in this field. There are two main competing positions states have taken regarding the services that an attorney may provide marijuana users and suppliers. Neither of these positions are taken by Missouri. Like I said, Missouri is just kind of in between when it comes to violations of the rules of professional misconduct. So the first approach is the strict compliance approach, which follows the federal law, not federal policy. It limits the scope of representation to advising about the law generally and prevents attorneys from providing business legal services or giving operational legal advice. So essentially, like the state of Ohio is one of the states that kind of take this, what is known as a restrictive interpretation of Rule 1.2. So the Ohio Supreme Court Board of Professional Conduct Ethical Implications for Lawyers under Ohio's medical marijuana law has stated that despite certain legal services being permissible under Ohio law, a lawyer would ultimately be assisting the client in engaging in conduct that the lawyer knows is illegal under federal law. So it's not allowed. That opinion out of Ohio does also say, however, a lawyer is permitted to explain to the client the conflict that currently exists between state and federal law, the consequences of engaging in conduct that is permissible under federal law, but contrary to federal law, and the likelihood of federal enforcement given the policies of the current administration. The rule does not preclude a lawyer from representing a client engaged, a client charged with violating the state medical marijuana law, representing a professional license holder before state licensing boards, representing an employee in a wrongful discharge action due to medical marijuana use, or aiding a government client in the implementation and administration of the state's regulated licensing program. The second approach when determining whether or not it would be a violation of the rules of professional conduct is what's known as the safe harbor approach, or it's really a permissive interpretation of Rule 1.2. So that approach follows federal policy. So it's the exact opposite, not following the federal law, but following federal policy. States that the lawyer must advise the client to comply with the state law, and the lawyer must warn the client of potential implications under federal law. The state of New York has kind of taken that permissive approach, and under the New York State Bar Association Committee on Professional Ethics, Counseling Clients in Illegal Conduct, it has been determined that Rule 1.2D does not forbid lawyers from providing the necessary advice and assistance. Lawyers might provide a range of assistance to clients seeking to comply with the Compassionate Care Act in New York and to act consistently with federal law enforcement policy. This legal assistance would be entirely consistent with lawyers' conventional role in helping clients comply with the law. So basically in New York, the committee did not believe that by adopting Rule 1.2D, the state judiciary meant to declare a position on the debate or meant to preclude lawyers from counseling and assisting conduct that is legal under state law. So what areas of law are clients looking for representation? As I stated earlier, when I got into the medical marijuana or cannabis law side of the practice, I quickly realized and understood that the needs of the clients ran the gamut. So you had some more sophisticated clients who already knew about corporate formation, governance, and advice, and had those things in place and really just wanted someone to help them complete the application, make sure that all parts of the application, which was very extensive, make sure all of that was completed, all of the I's were dotted and the T's were crossed. And then you had clients who came in and said, hey, it's me and my 4 buddies. We'd like to apply for a license. How do we do that? In addition to corporate formation, governance, and advice, you have clients looking for business strategies, needing help with business strategies and advice, employment litigation, or just labor and employment advice was a huge one, because again, once an individual had obtained a license, then they had to go into the compliance part of it. And a lot of that was training their employees properly, making sure that training materials were readily available for their employees. And that training included, sexual harassment, security protocols, how to get rid of marijuana, how to store it, who to sell to, all of those things. No surprise that there's a huge need in the cybersecurity and privacy risk management. Keeping in mind that this is medical marijuana, so you're looking at HIPAA issues, just protecting client confidentiality, things of that nature. Corporate transactions, as I stated earlier, regulatory compliance, which is ongoing. It's going to be an ongoing need for any clients that are in the medical marijuana industry. And then licensing, which for the most part is obsolete at this point. But if at some point, like I said, the state decides to open up the licensing program again and award some more licenses, then clients would need help in those areas. So when thinking about representing clients in the medical marijuana industry, it's important to look over and review your intake procedures and engagement letters. Those can be helpful tools in preventing ethical violations. Intake forms can be used to determine whether the purpose of the visit involves marijuana from the outset, and then you can make a determination from there if this is actually something you want to be a part of or not. A huge tool would be engagement letters. Engagement letters can and should convey to the client the scope of any attorney services. A well-drafted engagement letter should inform the clients of the relevant state law, advise as to the meaning of and compliance with state law, the potential consequences of violating related federal law. And by that, I mean, make sure that the client acknowledges and understands that the cultivation, production, and or distribution of marijuana or products containing marijuana or other cannabinoids is illegal under the federal law. And also that your client understands that they are subject to arrest, prosecution, and forfeiture of assets by federal government authorities for engaging in those activities, notwithstanding Article 14 of the Missouri Constitution and any statutes or regulations thereunder. Also, your engagement letter should contain the limited scope of the attorney's confidentiality and attorney-client privilege should any issues result in civil or criminal litigation. As I said earlier, those simple steps offer safeguards around ethical violations for attorneys practicing in states that have legalized some form of marijuana. Can't stress enough, if you're interested in representing clients in the medical marijuana industry, you have to be on your P's and Q's and make sure that you take the appropriate measures to safeguard your practice. So some things to remember if you are interested in representing clients in the medical marijuana industry. One, this is a new area of law. As I stated earlier, it's very fluid, it's ever changing. Even though there are other states that have done this and have been doing this for decades, it's still new to the state of Missouri. And so there are a lot of kinks being worked out, a lot of things that are being figured out pretty much on the fly. So you have to be prepared, as we are as attorneys anyway, to kind of stay abreast of the new laws and the ever-changing laws when it's related to the medical marijuana industry. Cannot stress enough that marijuana is illegal at the federal level. There are some things in place that allow for it to be sold, possessed, used, distributed at the state level, but make sure you are reminding your clients that if they want to get into this industry, they really have to abide by the rules. They can't let things slip through the cracks when talking about medical marijuana. Make sure you understand what is allowed and what isn't in representing clients in the cannabis industry. Like I said, the state of Missouri, when it comes to the professional rules of conduct, they haven't given us much guidance. And so we're kind of in limbo. We're not necessarily a permissive state, but we're also not a restrictive state. It's kind of just, hey, go out there and pretty much don't break the laws. Utilize your resources. So there's a small number of attorneys in Missouri who are practicing cannabis law, and they have a wealth of knowledge, but also we're all still learning this as things come into play. Again, it's only been legalized since 2018, and And really, dispensaries and licensed facilities are just getting up and running within the past year. So it's nice to kind of reach out to those attorneys. But when I got into the industry, I made sure to go to various conferences. From those conferences, I met people from other states like Colorado and California who've been practicing cannabis law for quite some time, who had a wealth of knowledge, who worked at some firms that strictly only practiced in cannabis law. Reach out to those people, make those connections. That's really the best way to kind of understand what's going on in this area of law. And then lastly, just remember that communication is key. You have to be open and communicate with your client from day one. You can't hide the ball. Don't let yourself get overly excited about, oh my gosh, I have this, marijuana client. They want to do these great things. Be open and honest with them. Let them know what they can and can't do, and make sure you let them know what the consequences are if they do break the laws. That concludes my presentation. If anyone has any questions, I'm more than happy to answer.
Hey, Lauren, that was great. Yeah, just a reminder, if anyone does have any questions, I don't see any, but if you all do, we have a couple of minutes. I have a quick question, Lauren, if that's okay.
Yeah.
And it's, pardon my ignorance, but I was just wondering, so I believe in Illinois, medical marijuana is also legal, but for example, in Kansas, it is not, is my understanding. And has that come up at all? For example, if someone that lives in Kansas would try to seek to get a card in Missouri, can they do that? Has that, come up at all? I'm just not sure.
So keeping in mind that you have to be a qualified patient. And so even in trying to sneak and get a card in Missouri, one of the qualifications is that you're a Missouri resident. So it would kind of be impossible. I mean, people falsify documents and everything, and it can happen, but the rules that Missouri have in place is that you have to be a Missouri resident. But thinking about, like you said, we neighbor Illinois here on the east side of the state. And if you're a qualified patient in Missouri, you could not take your card to Illinois and purchase at a medical marijuana facility in Illinois. That would be prohibited. One, now you're looking at crossing state lines and those issues, and being subject to federal laws. So it just wouldn't be wise to do so.
And then I guess a follow-up question is, has there been any litigation in Missouri regarding this? I know it's pretty new since 2018, but are you aware of any litigation on the medical marijuana front?
The only litigation that I'm aware of is because we saw the statistics with those who were applying for licenses for facilities, and there were a lot of people who were disappointed that they did not get any licenses. So a lot of people filed appeals, and there was a lot of litigation regarding whether or not there was a right to obtain a facility license. And pretty much that's been the only litigation thus far in Missouri related to medical marijuana.
I do remember reading about that, yeah. Because as you mentioned, that not very many people got them. So I guess they weren't very happy with that. All right, well, I don't see any other questions, and we've come to our time. So thank you very much. It was very informative, and I see you have your email there and your phone number. I'm sure you're happy to talk to folks if they have questions after this. And I will conclude our webinar right now, and everyone stay safe and stay healthy. So thank you again.
Thank you.